Okay, so I will shortly present you, Heike. It's okay?
Yeah, of course.
Okay, so welcome everyone. We are delighted to host with us Heike Krieger, who is a professor of international and public law at Freie Universität Berlin, a fellow at the Max Planck Institute for Comparative Public Law and International Law at Heidelberg, and co-chair of the Berlin Potsdam Research Group, the International Rule of Law, Rise or Decline. Professor Krieger is co-editor of the Yearbook of International Humanitarian Law and member of the editorial board of the Journal of Conflict and Security Law, Oxford University Press. In the past, she acted as judge of the Constitutional Court of the State of Berlin and as counsel of the German government before the European Court of Justice. Today, we will listen to her discussion on discourses about the crisis of international law, a stock-taking exercise. Heike, thank you very much for joining us, and I am delighted to yield the floor for your presentation.
Thank you so much for the kind introduction, Tal, and thank you so much for having me with you, although not in person, but on the other hand, it's a bit easier this way. And I'm very grateful for having the opportunity to share with you some ideas and thoughts that are related to this research program you have already referred to on the international rule of law, rise and decline. In order to give you a better idea about what I'm talking, I have also prepared some slides, and I hope it works. Do you see it? Yeah, fine, wonderful. So yes, the paper I sent you, well, it's not really a paper. It's, as I said, more work in progress. It comes from this research project, the International Rule of Law, Rise or Decline, about which we started to think in Berlin already in 2013. We became active as a research group in 2015, and now we are slowly approaching the end of the project. So it's time to draw the results together and kind of create an overall narrative from the results that we have found. And part of what I want to talk to you about today is the attempt to create an overall narrative on whether we see a new type of international law emerging from what many observers perceive as a crisis of international law and of the international liberal order more generally. The whole idea, also the project, started from the observation that international law, as it unfolded after the end of the Cold War, has not continued to thrive, at least for the last 6-7 years, maybe. I mean, it became evident for everyone with Brexit and the Trump election, but I think many indications were already present at an earlier date. I just can, and that is a stark contrast to what international law looked like in the 1990s, when we had the intensive activities of the Security Council, the spread of international adjudicatory bodies, the entering into force of multilateral treaty conventions, a boost in human rights protection, and all in all, for many, at least Western-based observers, a very positive development of international law that international relations have described as processes of legalization and juridification or institutionalization. And that processes have evidently come to a stop, and many observers currently talk about the crisis of international law. And looking at that development, it becomes important to see what is just short-term, what is presentism, what is just a contestation in ongoing international relations, and what are more structural changes of the international law order. And that obviously gives rise to the question also methodologically, how can I identify more structural change of the international order? The first step in that exercise would be to understand what this crisis narrative is all about. And in particular, in international relation theory, the talk about the crisis of the international liberal order, as it has unfolded after the end of the Cold War, is very present. But also in legal literature, you find a lot of reference to the indications and drivers of this crisis. And just to sum them up, there is this sense that the loss of Western credibility, if there ever was one, was particularly strong with the interventionism of the period, especially with the interventions, starting with the Kosovo intervention, continuing with the US-UK intervention in Iraq, and ending with the Libya intervention. There was a lot of skepticism and loss of credibility on the Western side. The attempts for pro-democratic regime change have basically failed, not only in Iraq, but also in Afghanistan. The situation is at least problematic. We have simultaneously, we have an increase in geopolitical conflicts. In particular, the Crimea is an outstanding sign here, but also, of course, the South Chinese Sea. The role of the UN Security Council in Syria and other cases gives the indication that the UN is continuously not living up to its task. Simultaneously, we have a decline in Western economic power, several financial crises following each other, a shift away from multilateralism and a turn to unilateralism and bilateralism. For instance, in the Belt and Road Initiative is something that observers note, in as much as a contestation of certain values, especially in the field of human rights. Women's rights are probably the most significant case of that type of more fundamental contestation. And all this is accompanied by a rise of populism and nationalism, not only in the West, but maybe across the globe. So while these indicators are noted by many observers, as usual, the interpretation is more difficult. And especially in international relation theory, there is, there's quite a bundle of theoretical offerings of how to interpret this crisis. Some see it as a move towards a competitive world orders. Others emphasize the interplay between rule and resistance. And for many, it is above all a legitimation crisis of global governance. Those who point to the competitive world order usually take realist approach, an approach that emphasizes geopolitical power shifts and sees the reason for all these signs of crisis in a shift from the unipolar world order of the 1990s to a multipolar world order where powers like India, China, and Russia assert hegemonic claims and therefore also contest norms that are related to the liberal world order. Others say this explanation is not sufficient because it cannot explain why the US is simultaneously withdrawing from the international scene. And that is certainly a development that is not only true for Trump, but has started before, at least with Obama, and we shall see how it will continue. So they say this all is about rule and resistance. We've seen through the post-Cold War an asymmetrical world order where the US and its liberal ideas were the dominant force, and against that domination, resistance had to build up. And now we observe that keeping up against the resistance becomes more and more expensive for the United States, so that it might be a rational calculus to retreat from the international order and not to resist the resistance any longer. And in this context, they describe the 1990s as a kind of forced liberalism. A third cluster of explanations is widespread also in legal theory, and that claims that global governance had reached throughout the 90s such a high type of authority, and that the legitimation that could at the same time be available was not sufficient to justify the exercise of authority by these institutions of global governance, and that might be one reason why we currently observe so-called backlash policies. However, the approach is quite optimistic in saying that these backlash policies might be resisted by counter-mobilization through NGOs and other actors. So why should the lawyer engage with that? Why is that important? In the first place, if we as lawyers want to explain what's going on in the law, we can certainly rely on our internal perspective. We don't really need to know about the political context, because political context only becomes relevant when it is translated through a legal act or a political act, to conclusion of a treaty, into the law. But obviously, if you want to understand what's going on in a long-term perspective and make some broader evaluations about the resilience and the movement of the international order, knowing about reasons becomes more important. So the turn to international relation theory, I think, is quite an important element of the methodological approach to explaining the current crisis. But of course, all the theories I have introduced have so far more generally focused on the international order and not on the legal aspect of it. So the question remains, what's law got to do with it? And here I think you can basically distinguish two approaches to the role of law in the current situation. For some, law is above all an object of contestation and resistance. And for others, international law is above all a driver of the crisis. Seeing law as an object of contestation and resistance often stems from the perception that international law, at least as it has developed after the Cold War, is an inherent element of the liberal world order. Liberal world order being composed of human rights, free trades, multilateralism, and international law as its four defining features. Then any attack against the liberal international order is also an attack against the law, and this might often come from especially populist movements, nationalist movements. But often closely related, there is also this interpretation that international law is the driver of the crisis itself. And that is basically seen through diverse perspectives, which somehow have in common that they either see some of the very liberal elements, such as democratization and regime change and human rights, at the core of the crisis, or that they see the whole blooming of global governance as the decisive element. Especially from a trail perspective, it is the asymmetrical, unjust power structures of international law, which are not so much kind of driving the current crisis, but which are a persistent element of international law and became particularly dominant in the post-Cold War period, when the US could somehow, together with the West, establish a kind of post-colonial hierarchical international order based on concepts such as good governance, R2P, rogue states, unlawful belligerence, state building conditionalities. These were all seen as elements that remind the observer of earlier colonial and imperialist approaches to international law in order to, as I said, establish stern hierarchies within international law instead of relying on issues such as sovereign or concepts such as sovereign equality. But the important point about this trail criticism is not only to point to the fact that flaws in international law have a much longer history than just looking at the 1990s. And they obviously also demonstrate that the whole crisis is not only about power shifts between the US and China, but certainly implies a broader and challenges for the international legal order. Others have more taken the internal perspective of the law and emphasized conceptual overreaches in relation to, in particular, human rights law. John Tasiulas and Ingrid Wirth are particularly known for their approaches in this respect. John Tasiulas has very strongly claimed that we can only understand the current crisis if we admit that it is also internally generated by overarching concepts of human rights that protect interests and no longer basic human rights. And he's also very critical of the judicialization of human rights. And Ingrid Wirth has kind of resonates, actually, I think, the criticism raised from the trail perspective that certain doctrines developed in the 1990s favor the global north and have developed far-reaching claims that have never been universally accepted, such as the responsibility to protect shines up again, but also all other ideas of the human rights transformation of sovereignty. So while those authors see that a certain overreach might be behind symptoms of the crisis, others emphasize the missed opportunities of the 1990s, and that is the famous criticism by Sam Moyn or Philip Alston that international law has not sufficiently cared for social and economic rights, and that it is this biased or one-sided approach to human rights law that now creates the contestations, again, especially from the global north, but certainly not alone. And a fourth approach that Koskinen-Niemi has offered, and that is also quite much established within his general writings, is the idea that the turn to managerialism, the turn to global governance has undermined the international legal order because of a lack of legitimization, because of a disenfranchisement from the local audiences. And he claimed that the whole turn that we see, especially on the far right, against international law is not only a turn or an attack against the 1990s law, but goes further back to the whole idea that Wolfgang Friedmann has in the 1960s proclaimed, that we have witnessed the creation or the type of a law of coordination instead of a law of cooperation instead of a law of coordination. The problem that Koskinen-Niemi describes is the decoupling of political processes from technical logical developments. And I think that this is an issue that we will and might face again currently, because many of the political science approaches to explaining the current crisis somehow still focus on power relationships, rule and resistance, authority, ruling, but they kind of neglect that there is a second type of challenges for international law, which is related to the first type, but still independent of this. And that is all kind of material change or technological change and empirical change, if you want to, creating foundational challenges for political decision making. And I refer with that to issues of technical and factual developments, such as climate change, or artificial intelligence, digital currencies, pandemics. These are phenomena which require legal and social regulations, but where it is very uncertain to some extent whether law, at least in its traditional shape as it has developed throughout the 19th and 20th century, can still address that. In a point is the issue of agency and responsibility in artificial intelligence, for instance, or the issue of stability. Law, as we used to know it, is something that shall create stability. Artificial intelligence is about very quick shifts, so how can that be reconciled? Also, many of these phenomena are termed as wicked problems being problems that are not linear, or that do not develop in a linear way. So can law at all deal with that? So any understanding of what we currently see, I think, must definitely take into account both the strands that I have just described. Against that background, a question that has not only arisen within our research group, but is now more often around the place, formulated by Koskiniemi, for instance, or political scientists, is a question: what's now going on? Do we see a steady accommodation and adaptation of international law to changing circumstances, or are we somehow confronted with a kind of revolution? Where does international law go to? Do we see movement in this or that direction? And again, here you can already discern, I think, two basic approaches of how to deal with that situation or how to understand that situation. And the first one is a kind of, at least from the perspective of liberal international law or liberal international order, would be a kind of let's say, backlash or going back. And that is the idea that what we see now is a development into the direction of the necessary international law. That's a term borrowed from Vattel. And this approach sees the 1990s kind of as an exception. Many of the claims raised in the 1990s as discontinued legal developments and foresees that we will fall back, at least for the traditional international law, to the basic regulations on actors, sources, diplomatic relations, and some fundamental principles such as sovereignty and non-intervention in a more traditional understanding. And authors that rely on such approach can always point to, for instance, the Sino-Russian Declaration on International Law from 2016. That also goes hand in hand with the claim that law is probably not able to regulate the more complex technical issues that arise now, so that we would probably see a certain split in the development, the necessary international law and the traditional way, and things regulating artificial intelligence and other areas would develop into something new and not the traditional kind of law that we know. From another perspective, the crisis is just a slump. This is in particular global constitutionalism, which somehow clings to the continuing progress narrative, admits that there are some flaws in international law of the 1990s and tries to address these flaws by being more inclusive, by opening up to cultural pluralism, also in human rights protection, at least to some extent, embracing social rights, thereby somehow relying on an idea of self-healing powers of liberalism, but still, pursuing the overall progress narrative and hoping that with the help of NGOs, civil society actors, and democratic states, the liberal idea behind international law will somehow preserved. Both approaches, and of course these are mere simplifications, both approaches suggest that we have more of an accommodation and adaptation going on than revolution. And that is easy to explain because there is, I guess, a widespread reluctance to think in terms of paradigm shift. There are different reasons for that. Some of them are more pragmatical, others are more conceptual. On the one hand, we don't, and I think there is some agreement that until now we don't have a real conceptual counter-narrative for the liberal idea, for liberalism, for the liberal ideology, if it should lie beneath international law. China has not yet developed a full-fledged counter-narrative. Also, populism more or less glorifies an unspecified past, but does not really offer new alternatives. And probably most interesting, also on the left, on the political left, it's difficult, at least in Europe, to discern new ideas, new concepts for where we should go to. Instead, much is retold in the frame of the existing narratives. Obviously, there are some advantages in such an approach. Path dependencies must be taken into account. Adaptation and accommodation might probably produce lower political costs, may be conceived to be more legitimate, and is also anyway probably limited by the political context and the surrounding power constellations. What I also found very interesting is that some of the thinkers or philosophers on global justice, especially Matthias Risse, has quite explicitly claimed that we don't even have any alternative. We should especially not think about global justice outside the term of the state society in the international order, because he thinks here we are subject to some fundamental epistemic limitations on our utopian thinking, because we can't really know what it would mean to live in an international society without states. It's better not to try, because we cannot calculate the consequences. As convincing as that may sound, I still think the problem is that accommodation and adaptation that continue to go on will at some point reach a tipping point when they turn into something new. So you still cannot escape the question whether we might see a new type of international law developing. And then, of course, the question remains how to identify that in terms of methodology. And for that, I think one can identify a number of methodological approaches or indications how we might see that international law is really turning and developing into something new. And one approach to do so is thinking in terms of types of international law. This approach can rely on earlier attempts to do so. I have already quoted Wolfgang Friedmann, who is very well known for his book, The Changing Structure of International Law from the 1960s, where he described that change or that creation of a second or third layer of international law from a law of coordination to a law of cooperation, a narrative which is still with us. Of course, types always idealize, they overemphasize certain dominant aspects, but by doing that, they help to create a foil against which you can evaluate change. For law to see change, I think there are certain indications to which you should primarily look in order to analyze such a change, and that are the foundational elements of the international legal order, including its values, institutions, and structures, encompassing the sources and the actors, but also legal structures. So one way to see whether we face some more fundamental change would be to look into the role of legal values embodied in international rules. Do they change, or do we even see a delegalization of values? Is the whole idea that law should embody certain values contested? That would be indications for a more fundamental change. Likewise, legal structures in themselves could change, not only actors or certain foundational rules on how to make international law, but also the regulatory techniques or the norm structures, or if certain standards rise. In the paper, I give the example of due diligence. The proliferation of due diligence standards in international law may be explained as a structural shift in response to the turn to the risk society in international law, away from regulating harm towards managing risk. And that is then something that will also be reflected in the very structure of the norm and can be an indication. But another very important indication is probably the dissolution of established categories. And an interesting example in that respect, I think, is currently what is going on in climate change litigation. it's just some 15 years ago that climate change cases were not very successful, while currently we see really an explosion of successful climate change cases, at least in Europe. And the German Constitutional Court, for instance, made a very important decision in this respect, and in a decision which also, to my mind, has some more fundamental dogmatical consequences, because it dissolutes certain categories with which we are accustomed to think in legal terms. And that is the idea of the state and sovereignty as something about inside and outside, who belongs to a constituency, who can bring claims for legislative change through democratic organs. It's about present and future, shifting responsibility and accountability by dissolving temporal categories. And it's about inside and outside, shifting responsibility and accountability by deterritorializing responsibility. So in many ways, the binary and territorial character of sovereignty in such an approach is dissolved and would point into something really different. A last clue that I just want to mention here for tracking change also in legal discourses is finally a more indirect one, and that is the use of metaphors. If we look to language and if we see what metaphors are used, we might deduce from those uses whether authors observe more fundamental changes. A good example for that is, for example, Eyal Ben-Venisti's concept of sovereigns as trustees of humanity, which would relate to that Constitutional Court decision of Germany, taking a metaphor from business law or a concept from business law to international law in order to explain the change and emphasize the deterritorialized accountability and responsibility. So to sum it up, I think the challenge now is indeed to understand what is going on. We for instance, in our research project, we have a lot of analysis on the different things that go on the interactions between the different actors involved in the diverging legal regimes, but it's still difficult to put it in an overall narrative. And one issue that seems to me to be important in this respect is actually that the whole metaphor of crisis is probably not the right metaphor, because crisis in a way prompts and continues to prompt linear narratives. A crisis is then a stage and a sequence of events that at a certain point in time then changes and turns into another direction, but it's still a linear idea. It's about turning points. Probably that's actually not so much what we are currently seeing. I guess that the metaphor, and that's what the picture refers to, I've shown here, a better metaphor is that of sustained and protracted turbulences and ambivalences. Because in as much as the German Constitutional Court might push into dissolving certain understandings of sovereignty, and as it has done in the past, at the same time, we still have China and Russia, which cling to a very traditional understanding of sovereignty. We have turns to unilateralism and bilateralism without really knowing whether this is the same kind of bilateralism that we have observed in the past. So the overall situation is particularly unpredictable. And approaching this, I think, really means to develop certain standards, certain yardsticks to compare the change, and then see it again a more protracted form of turbulence and more protracted form of turbulent international order in which we currently are. So thank you for listening to me, and I hope we can have a discussion now that I'm very curious to hear what you think about all that.
Thank you very much, Professor Krieger. It was very interesting and very broad. I think that we can open a discussion almost about every point in the presentation. I see that we already have some hands which are waved, so I will let them begin the discussion. Yalin, please, Dr. Shashevsky.
Yeah, thanks very much for a really interesting presentation and paper. You finished by saying that you find it challenging to have some kind of overall narrative, and I wonder whether there is an overall narrative to all of the different phenomena that you've described. So, for example, is there a connection between the new rise of China and Russia in international law to the issue of new technological changes, AI, and or the rise of informal international lawmaking? I'm not sure that there is. So for example, Russia and China is often associated with return to traditional hierarchies, and I'm not sure to what extent does it meet the rise in informal lawmaking in the past 20 years. Right, and technology is changing regardless of some geopolitical tensions. And I think that there are many attempts to address some of these phenomena, but I'm not sure what is the value and whether it's correct to see everything as part of this broad trend.
Shall I answer directly, or yeah? Okay, fine. Yeah. Thanks for that comment. Obviously, I mean, whole Welterklärungsmodels might be a very overambitious task. That's for sure. And you're right that there are some elements in technical development that are not necessarily connected to geopolitical power shifts. But I think that seeing these things together is still beneficial to understand what is going on for two reasons. On the one hand, the starting question is not so much explaining what is going on, but what does it do to the law? And both things do something with the law. So for a lawyer to understand how the international order changes and why we probably won't see the formalist classical type of international law that still has striven in the 1990s to some extent, or yeah, it has, and why that will probably cease to be the case. I think for that you have to take into account both developments to explain that, because both exert some pressure on the traditional picture. And on the other hand, I think you also see that these mechanisms are, at least in some areas, interrelated. For instance, something that springs to my mind is China's role in discourses about internet access. That is, on the one hand, about the difficulties of a new technology. But on the other hand, what China is currently doing is really trying to establish itself as a norm maker, advancing interpretations on the right to access that diverge from the American interpretation. And so that is also an example for contestation of the liberal legal international order. So I think there are still interconnections, but you're utterly right. One should be careful to make a too broad story.
Thank you very much, Heike. We have another question from Shoshana Be'eri, but within this forum, we have the permission to refer her as Shoshi. So it's up to you, Heike. Please, Shoshi.
Oh, I can't hear you.
Can you unmute, Shoshi?
Thank you very much for the article and for the interesting lecture. I wanted to ask you, what do you think about Eric Posner? He was in the forum in about 4 years ago, and he was with his article about what happens, what's going on with the international law as the backlash of popular regime, and he was saying that it starts as opposition to globalization, and he says that it's the changes are because it's periods of centralization and decentralization, and that it's not linear, but it cycles.
Mm-hmm. Yeah, thank you for that question. Populism, populist backlash, opposition to globalization. I think there are different levels. I think on the legal level, one can observe that some of the populist governments undermine certain concepts that are related to this idea of a law of coordination. There is a certain tendency also to step back from multilateralism. There is a certain tendency to challenge a certain type of human rights, in particular women's rights would be an example, or LGBTI rights come under attack in this context. Also freedom of science is an issue here. So you have certain elements which also show that at least there is an indirect influence on the development of international law. But about the explanations for that, is that about centralization? Is that cyclic? I mean, some sense of a cyclic development I think it's something that you can have. There are certain, or one might be tempted to compare certain developments, at least to periods earlier in the 20th century. But I think that, or in generally, I'm a bit uncertain about this managerialism narrative, saying that this turn to expert rule and depoliticization of certain processes furthered populism, because I'm not sure that, not being or not really, well, that maybe there is a sense that certain parts of the population have not been heard, but I'm not sure that this is really accurate. I find the explanation much more plausible that many of the basic values that were established since the 1960s and got support in the 1990s were simply not that consented to. That many of the so-called elite of the liberals had the human rights activists, human rights lawyers, myself, that we all had the impression that there was a stronger consensus on certain values even within the Western societies than there actually was. And that many of the old stereotypes and problems remained, and that they are now coming to the surface. So I think it's not so much a problem of managerialism, but of how to establish certain values more sustainably. At least my sense.
Also, talking on changes from the Roman period. He's not talking on the last century. He's talking while looking on international law during the historical periods.
Yeah, I mean, there are narratives in explaining a change in international law that always relate the dominant concept of the international order to the hegemon of that period, like the Spanish period, the English period of international law, the US period. And I think there is something in that narrative, and of some of the and I guess that goes back to the idea of competitive world orders that we might now see, that we simply see a change of the hegemon, that at least China trying to be the hegemon of a new order creates the turbulences in the interpretation and application of norms. At the same time, I'm always kind of hesitant to or let's say, I would warn against completely going down this narrative of international law is the international liberal order, because in a way that harms the very function of international law. It might be that the US and the West try to use international law in that way, but I don't think that international law necessarily needs an ideological grounding in that sense, and that it can fulfill many of its purposes much better if there is no, let's say, no thick ideological grounding. That is the whole idea, that international law then can work as a framework for contestations, that there should be some room to give different ideas about human rights protection. And if it is just in a thick manner liberal internationalism, that might actually be a problem for international law. So I think there is a double aspect to that narrative, and one could be more critical about it.
Thank you.
Very much. We have a question by Moshe, who has returned from the virtual campus of Freie Universität Berlin. So, Jerusalem, Moshe.
I'm sorry for being late, but of course I've read your excellent paper. I have actually, my question, it is related to the previous question. In the first part of this paper, you write that one of the major reasons for the decline in international law, it is about resistance by many countries to the international liberal order. And then you write, you have a very interesting section about the constitutional approach, and you believe that the constitutional approach or the neo-constitutional approach may resolve the problems. But actually, I think that in most cases, the constitutional approach has quite a significant liberal dimension. So we remain with a lot of resistance. Or do you think about the constitutional approach without democratic values, for example? I mean, I have some students that believe that some states don't want to be democratic. And is it okay with the constitutional approach, or it has something to do with it?
Thank you so much, Moshe, for that question, because it shows me that I need to be more clearer in my wording, in my phrasing. I'm just kind of summarizing two approaches that you currently can observe in the literature. I'm not aligning with the constitutional approach. Actually, I've criticized it elsewhere because it actually brings me back to what I've just said. I would completely agree with you that while democracy is a good thing for many states, seems to be, I don't think that it is, phrase it differently. It's again the question how much ideology international law can take. And I would say that in a sense, it is better for international law to have more space for different approaches, so to work as a bracket, as a frame for all the diverging actors in the international order. So there should still be space for states that do not identify with democracy, for international law to be able to create peace or contribute to peace, to create and contribute to stability, to solving problems. I think, or I would agree to some extent with Ingrid Wirth, for instance, that some of the concepts of the 1990s were too unevenly promoted, I guess, and not paying enough attention to the contestations and to the resistance that was already there, but that nobody really saw because the US was as a unilateral power so powerful. I guess in the end, I mean, it's also difficult to say that we should return to that necessary international law, which is just about diplomatic negotiations and the like. I guess there must be a balance somewhere in between, as simplifying as this may sound. Sustainable development goals, for instance, are an example to show that there is a global consensus on more substantive values that should be promoted by the international community. But one should try to somehow, delink it from too much ideology, I guess.
So something like thin layer, small layer of values like don't do genocide, I don't know, racial discrimination, but not about freedom of expression or democracy.
Well, it's a tricky balance. It's a tricky balance to be done. Actually, I sometimes guess, and I still have to think about this, formalism isn't that bad. Once China and others have signed or even ratified human rights agreements where the freedom of expression is included, why would we give it away? But we should accept that it is a constant process of contestation, and I guess we need to be aware that China is now promoting very actively, for instance, the claim that there is no right to internet access, whereas the dominant Western interpretation would say, also the means of communication are covered by the provision. So we should be aware of these contestations, and I guess there are two levels. There's the normative level for actors and for us as actors to make, to say that to some extent we think that certain European values are not just bad values because they are European, but actually are very useful values such as freedom of expression and the like. But at the same time also take a step back and analyze the overall development with a lesser normative approach, maybe.
Thank you.
Thank you very much. Jonathan also wanted to ask a question, but it froze in my picture. Jonathan, are you with us?
Yes. Can
Perfect.
you hear me?
Please, yes.
Thank you so much. I really enjoyed the paper and the presentation. I have a question that's maybe less broad and more focused than the previous questions. And if I understood, it relates to the methodology of indicators of fundamental changes in international law. I think if I understood correctly, you seem to suggest that there's a third indicator that you mentioned in the paper, but not in the presentation, and that is the rising influence of different disciplines on international law. But I'm not sure I understood the argument there, because the law and movement has been around for a very long time, and there are clearly examples of its influence on international law in different domains. So I'm not sure I understood how more law and influence really indicates any fundamental change. It's already there in a way. Thanks.
Thank you very much. Indeed, I left it out on the presentation, and it's certainly the most underdeveloped argument yet. But I guess, and you're utterly right, of course, law and economics are something that is around for a very long time, no doubt about that. But I guess the underlying sense here also relates to this argument of complex problems and nonlinear development turn to informality. And that is the sense that the formalized binary kind of law, the yes and no types of categorization that law offers us are dissolving, and that insofar these other disciplines and the lawyers turn to other disciplines might demonstrate that the traditional law is to some extent really in a dead end road and cannot any longer explain what's going on, and is under severe pressure, and we might in the end really end up with something that is not the kind of law that, let's say, Kelsen has described, to pinpoint it somehow. And obviously that is going on for longer, definitely, but I think it has now reached also mainstream lawyers. That's maybe the difference. That the strong impact of this dissolution of categories and the like really influences courts now, influences mainstream academics, and it's and that might be an indication for the more fundamental shifts that we actually are observing. That maybe we lose formality and we lose binarity for more kind of management approach, which but in the end comes closer to politics than to law in the traditional sense. So that's the idea behind it, but it definitely needs to be developed further.
Thanks.
Thank you very much. So our next question will be by Yuan, please.
Thank you, Professor. It's a very interesting topic and very inspiring. I want to ask a question about your argument about the skepticism about Western liberalism, in particular with respect to the US involvement in Afghanistan, Iraq, and such. I think the failure or obstacles faced in Iraq or Afghanistan does not necessarily mean the problem of Western liberalism, because the two countries have a very serious geopolitical and factional strife, very complicated issues, which cannot be dealt with by a simple solution. And I also want to comment on your argument about the ideology. I recall you mentioned international law can provide a framework, allow more contestation. And so I want to ask your opinion about the relation between democracy as Western liberalism and human rights protection. If human rights protection is reflect universal value and customer international rules, then I think democracy got to be involved as an integrated part, because even China has signed up the Human Rights Treaty, and it never ratified it. And I don't believe without reform of the political system, without implementation of pluralism, the ruling party will genuinely implement the treaty. So that's my observation.
Thank you. These are two very pertinent observations. The failure in Afghanistan and Iraq is not necessarily related to Western liberalism. I agree that especially in Afghanistan, the failure of establishing a stable state, let's say, is indeed also owed to the particular situation on the ground. But at the same time, I think the whole legal circumstances of those both interventions have undermined Western credibility. The fact that in Iraq there was no proper legal basis in US Security Council resolutions, the way in which Iraq was administered by the US, Abu Ghraib just as one keyword in this relation, and also in Afghanistan. Afghanistan is maybe lesser a point than Iraq. Iraq, I guess, has a stronger symbolic value, but that the whole idea of intervening in order to build up a new regime top down, I guess, that this did not turn out too well is in my view, quite acknowledged by politics as well. I mean, many approaches that are pursued, for instance, within German foreign politics, go now bottom up. There is much more support for local initiatives instead of doing kind of occupation regimes. I think there's a failure there, but the most important issue in relation to the credibility of the West is the uneven and selective application of UN Security Council resolutions. You can, for instance, trace that an annexation was only condemned by something like 160 states or so, and many important BRICS states not participating. South Africa, for instance, not participating in the condemnation, but abstaining because they said, where's the difference to Iraq? So the West kind of gave them cheap arguments with this circumvention of the Security Council. I still think Kosovo and Iraq as a circumvention of the Security Council was a major blow to the credibility of the West. I would still claim that. Contestation, democracy, does democracy need to be an integrated part of human rights protection? I'd say yes, in an idealized world, without doubt. I mean, my normative ideal, let's say, would still be a human rights protection based and integrated with democracy. But the international order is a messy affair. And I guess that's also my problem, probably, with certain interpretations from constitutionalism and the like, that they don't take into account sufficiently that international order is messy and that many actors do not stand up to the idealist claims. So while this can be a far-reaching normative ideal on a more meso level and on a shorter approach, you need to find day-to-day approaches how to improve human rights protection and keeping the international order intact. And I guess that's my concern in that respect.
Thank you very much, Professor Krieger. Our next question will be by Shani. Please, Shani.
So thank you very much, and it was a very interesting presentation. So I have two quick questions. One is that the analysis in the presentation referred to international law capital as one concept, and I wonder if it's true for all subject matters of international. Is the decline and resistance in changes and effects in international law, so-called, would be the same in every subject matter of international law, or it would be more efficient to examine each subject differently because it's behaved differently? And the second question is, what do you, when the analysis refers to international law, what is international law? For example, does it refer to practices that downplays certain rules or add informal rules? And then what seems like new practices or new order might not be so new. So I just wonder if that would affect the analysis. Thank you very much.
Thank you very much for two very pertinent questions indeed. Yeah, within or when we first approached this project and the whole idea together with Andreas Zimmermann, by the way, and Georg Nolte, we also faced that question: can we at all talk about international law at all? Because obviously the fragmentation discourse is there and other discourses. So isn't that a very pretentious approach? And I'd say this requires a twofold answer. On the one hand, you are utterly right. We don't have the same type of development in all branches of international law. The law of the sea, for instance, is probably, despite the South China Sea dispute, all in all, a very stable regime, which seems to work more or less unaffected until this very date. So does it make sense to speak about international law as such? I think we opted for that, or at least made that broader claim, because the developments may be interrelated, and because one can then also observe impacts from one regime on the other. I mean, common sense tells you that it will probably not be the whole of international law that develops differently, that develops in a crisis. But if you can see, these are the areas that are affected by the crisis, and these areas are not affected by the crisis, this can also tell you something about the reasons and the drivers. For instance, the example of the law of the sea somehow seems to suggest that a strong institutionalization, courts that are more or less active in the field could be a factor to stabilize the regime and to bring about more permanent change. Of course, it could also have to do something with the highly politicized areas. Use of force, obviously, is always a specific topic. Human rights is a politicized area, so maybe that is one of the reasons. But all in all, I guess it's still important to, especially if you want to address the question whether a new type is coming up, it's also still remains important to try to get an idea of the whole picture. Yeah, and after all, there are always interconnections, interconnections between the different branches, where the different branches of international law interact. So if there is, for instance, an impact on treaty law, if there is a turn to informality for power politics reasons, then you will see that probably in all branches of international law. So that's why we took this broad approach. Oh yeah, and the question for the practices, what is international law? I mean, if we come with that kind of question, our understanding of international law is a traditional understanding of formal international law. I mean, that's what we're curious about. Does formal international law change? But there are, and I think there are more openings in formal international law for all kinds of practices than some observers at least think. So subsequent state practice, practice within customary international law might allow to bring in and to understand certain political practices also as being part of formal law. So we think it is still worthwhile to take this traditional formal approach in the first place in order to then maybe also distinguish which practices are still practices that can somehow be integrated in this traditional understanding, and which practices definitely fall out of this paradigm and might indicate more fundamental change.
Thank you.
Thank you very much. To follow up from that point of the discussion, Professor Krieger, what kind of change should we look at? If we look at the paradigm shift after the big war and the Second World War, we can say that the shift was the rise of the rise of international organization, which is a new player, or the rise in the protection of the individual within the sovereignty of the state. Now, those changes are considered as paradigmatic, to my understanding, given the fact that they touch the nature of international law, the state-centered nature, Westphalian nature of international law. Now, the spectrum in these current days is more about whether we're going for more cooperation or more nationalism or stricter views of states. Now, how can we look at this spectrum and elevate it to the level of a paradigm shift? What kind of shift will elevate it or will be strong enough in your view?
Yeah, that's a tricky question in the end. I would suggest that indeed the major issue is still the role of the state and what we how we conceive of and how international law would deal with the state. That's the one point. So do we maybe really see deterrorization? Do borders lose their role, or is it enforced? Do we really think of more forms of shared accountability, broader accountability? That's what I talk about the categories, and that basically refers, or in the first place refers to the state. If we see a stronger pressure on sovereignty by closer look, then I guess there would be a certain paradigm change. And the other paradigm change, I guess, would more basically affect the role of law. And that is if we, in many, well, the basic idea of law is somehow that it can regulate everything. I mean, that's, I think Bruno Latour said that you can draw everything into the law. And I guess that is what has dominated the lawyer's perception for a very long time. We can talk about everything in terms of law. And if we should find that this is no longer possible, that we have severe fields within social regulation, technological regulation, that we can no longer address in this very traditional binary character with legal, illegal, good or bad, permissible or impermissible, then that would also mean a paradigm shift, in my sense.
Thank you very much. It's very interesting. I have a follow-up question, but I also saw that Moshe raised his hand, so he has the first right for a follow-up question. So please, Moshe.
I also have a follow-up question. Actually, it is relating to the question raised by Shoshana and me. I think that the daunting challenge that is resurfacing in different sections of this paper is how can we reconcile between promoting international rule of law and not enforcing too much Western values. Yeah, again and again. So one idea, perhaps it would be good to highlight or to underscore the distinction between global international law and regional international law. I mean, thinking about global international law is to admit that here that values would be minimal, unfortunately. But if we would like to promote Western values of democracy and so on, so we can do it, but in the European legal system, in the inter-American system, but we cannot do it in Africa or Southeast Asia because they have different values. I think, I mean, I know that there is some problem because constitutional approach with regard to values, it must be universal in most cases, but perhaps it is to admit that we can promote such values only in regional clubs, but not really on the global level.
Yeah, thanks, Moshe. I think that is a very important point, and you're right. This is really the underlying conundrum somehow. How can you promote the international rule of law without making it the liberal order? And even, I mean, there is also from the global south a lot of justified criticism yeah, also this value talk is form of imposing certain hierarchical forms of understanding international law. I agree with you that the regionalization is an important element in this development. Some see it also as a challenge. Obviously, those who want a broader value-based global order see regionalization as a challenge. And I think it goes hand in hand also with the whole pressure that is currently exerted on all debates or on the whole concept of the universal. What is universal? Are any of these values really universal, or is it just Eurocentrism, maybe even bolstered by capitalism? So I think there is a lot in this approach. At the same time, what I find interesting in what we have looked into in the last years is that in relation to many of the legally enshrined values, it is difficult to state to date that they have really eroded. There is some contestation, there is some pressure, but torture hasn't really eroded. It would be very difficult to prove that. And also sustainable development is something to which many states subscribe in their practices. Of course, counts on what practices you count in, but and also in other fields of human rights. So women rights are something where you see in the West, but also in the global South, strong pressure, withdrawals and legal contestations, LGBTI rights, as I said, freedom of religion. There are, of course, different interpretations, which might exert a stronger impact. So to some extent, I think we should also be careful to throw out the babe with the bath too early, with the bathtub too early, because something that we might also observe currently is how resistant formal international law may actually be. And that brings us then to the question, what do we lose when we lose formal international law? Because this making everything in a yes and no dimension is a very powerful tool. And in order to change this yes and no, you have to really build up a strong resistance. As Campbell McLachlan always said, you can't create international law with one hand clapping. You always need two hands. And as long as you don't get the second hand, it doesn't change. So the resilience and the persistence of international law is also a factor here that we shouldn't underestimate. So yeah, it sometimes sounds like a sheep answer, but there's a lot of ambivalence in the whole situation still.
Thank you.
Thank you very much, Professor Krieger. I think we are getting to a point of needing to conclude, and I wanted to invite you to present your general conclusion, but I actually thought that by now we will be talking heavily about COVID-19, something which did not happen. So maybe you want to entwine your conclusions to how you see the pandemic of relevance to the move or the trends that you talked about. Because on the one hand, one can claim easily that the state's responses was primarily national and nationalistic in their view and etc. But on the other hand, we know that the WHO did promote and quite a lot of, for example, assistance for developing states, and also coordinated significantly when it comes to the race for a vaccine. So the COVID-19, some have raised the question, right? If the COVID-19 is a paradigm shift, but some try to answer, like Yuval Shani is not able to be here with us. He's on the family vacation in the South. But on his behalf, we can say that in the view of Yuval Shani, for example, well, COVID is just more of the same stuff. So how do you see the pandemic fitting in your observations?
Yeah, thank you. Thank you for that question. Indeed, I have circumvented COVID-19 to some extent. Because I think we have very different signals again. I think on the one hand, as you said, the closed boundaries and all that might be interpreted as a return to nationalism, but I'm not so sure about that. I guess the emergency situation of the whole situation had a role to play. But I think there are some elements in the whole crisis that somehow point to future challenges. And well, from my perspective or standpoint, well, or let's say there are some political structural international order issues here that I guess are relevant for the overall discourse. And that is, on the one hand, the fact that China currently at least is able to claim that it has very successfully handled the pandemic, that especially Europe, the broader West, have not been so successful in handling it. And I wouldn't contradict this, at least at the first place. But anyway, to some extent, that crisis has also undermined Western credibility, also because now, and I don't know exactly what the role of the US is here, but because Europe at least is counteracting any ideas of waiver of patent rights. So this, of course, gives it a very bad position in moral terms, ethical terms, in terms of global justice. I mean, one can argue whether the Biden administration was not playing on that and was that therefore so gracious. This argument is around, actually. They thought Europe would say no, so they could afford to be generous, to look generous. But that is an issue, I guess, that the West again is losing credibility here and legitimacy above all. The other structural thing is the unpredictability. I think it shows us again how difficult it is to deal with certain material challenges because things are so unstable and unpredictable. Developments become so uncertain, and that is really a challenge for law, which actually, I mean, international law tries to regulate things for several hundred years. That doesn't work anymore, obviously, and I think the pandemic has clearly shown that there are some limits to processes that take long for negotiating a treaty and things like that. That is very difficult as an instrument to react to something like a pandemic. That's on the structural and probably more negative side. On the more positive side, of course, you have already mentioned the WHO coordination through international organizations, and in the past, such events have been means to instrumentalize more fundamental change in perception and in the role of international institutions. So there is this positive side too. And also, I think what I found actually interesting is that among my students, this issue of patent rights and waiver of patents rights and the role of Europe and the lack of international solidarity was something that all of them immediately criticized very heavily. It made the whole issue of global injustices much more tangible. For at least aware people, woke people in the global north than other topics. And I think that might be quite a driving force indeed for change, but one has to keep the momentum, I guess, to bring that about. So a complex situation as always, but my overall sense is, or the question that I really want to, in the end, hopefully somehow answer when we come to the end with our project, is how much of traditional international law can really remain in these situations, and how much will we see that law as a regulatory instrument goes away or develops into something substantively different. Yeah, thank you so much.
Very interesting discussion, and we truly hope to properly host you next time in Jerusalem.
Oh, that would be wonderful.
You have an opening.
That's nice. And first I will see Moshe hopefully in Berlin at the end of this month. So.
Lucky Moshe.
No, thanks again. It was very interesting for me to interact with you on that and to get some more impact on how to come to these.
Thank you very much, and welcome everyone.
Thank you very much. Excellent. Yeah.
Thank you. Until next time.
Yeah. See you. Bye.
Bye-bye. Thank you very much.